Hey, Paul here again, and in this video we're going to talk about the conversation that married couples should have about who they should give financial power of attorney to. All right, so virtually everybody who gets their legal affairs in order, they're going to sign one or more powers of attorney. Here's why. Because if you don't sign a power of attorney and at some point during the rest of your lifetime you get to a condition where you are unable to do things like sign your name, take care of your accounts, pay your bills, sell your vehicle, deal with the IRS or with the government or Social Security. If you get to a point during the rest of your lifetime where you can't do those things for yourself and you haven't signed a power of attorney, then it gets to be pretty chaotic. If that happens, what's the next events that are likely to happen would be your family members would have to come hire some lawyer like myself. We'd have to sue you at the courthouse in some type of guardianship proceeding. You don't know what's going on, but the sheriff serves papers on you, and at least in our Louisiana procedure, the court appoints a lawyer to act oversee what's in your interest, and your family has its own set of lawyers. It's a process that goes on and on and on, very expensive, very difficult, a hassle for everybody. So that typically, all that can be avoided if you, while you're healthy, sign powers of attorney where you select who you'd want to be able to do things for you in the event at some point during the rest of your lifetime you can't do it for yourself. Okay, so a couple of points here. People ask me occasionally, so Paul, whoever I designate on my power of attorney, so that means that after I die, they can go deal with my accounts and pay my bills that I had outstanding and that kind of thing? And the answer is no. So the power of attorney is who can handle things for you during your lifetime. It expires when you die. Now, as part of getting your legal affairs in order, you're going to be making other designations, and those other designations that you make may be the same person that you designate as having power of attorney. But once you die, your power of attorney stops having any legal effect, and then perhaps the executor of your will or the successor trustee of your trust will take over, maybe the same person, maybe it isn't, and deal with those things that need to be dealt with after you pass away. All right, so this appointment that you make on your power of attorney, I'd say it's probably maybe one of the most, if not the most important designations that you make as part of the estate planning process. And in this video, we're really focusing on the, sometimes people call it the financial power of attorney. Some people call it the property power of attorney, as opposed to the healthcare power of attorney, the medical power of attorney, the healthcare proxy. That'll be another discussion about who you should designate there. So this is really for financial, business, real estate matters, who you'd want handling those kinds of things for you. The reason it's such an important designation is that people are living longer, and many people unfortunately become incapacitated. So that's when this stuff kicks in. Now, the right person that you designate, if you do designate the right person, they will be the type of person who will take their job seriously. They'll monitor your assets, your accounts, your holdings. They'll monitor your bills. They'll monitor all of that closely, and they'll make the necessary financial moves that are in your best interest. The wrong person that you designate on a power of attorney, they literally could take you to the cleaners and steal all of your money from you. Most people have heard a story or been involved in a story where a person gave the wrong person power of attorney, and that wrong person did some things that they should not have done, but they had the kind of ability to go in and transact accounts, and it turned out to be a disaster. So if you pick the wrong person and they do bad stuff, it's very difficult to get recourse against that person because you're incapacitated, and then it just going through the legal system to get recourse against a rogue power of attorney is difficult. All right, so who should you appoint? And if we're talking about the married couples, you know, the overwhelming majority of times, married couples, when they do their power of attorney stuff, the overwhelming majority name their spouse first. So, husband signs his power of attorney appointing his wife first, and we'll get to second in a minute, but she's the first one who would have the authority to do things on his behalf. The wife would sign a power of attorney appointing the husband first to be able to do things on her behalf. But then, we always suggest that you name a backup or an alternate to your spouse. And so this gets to where, the couples are having conversations and trying to figure out what to do. I will say it's very common to name an adult child or children who would have your best interest in mind as the alternate agent on your financial power of attorney after you name your spouse first. So now, problems there that surface, not problems, but issues that address when we talk about going down to the children, secondarily, is many people have more than one child. So they're like, do we have to pick one, or can we name all of them? Can we name both of our children? Can we name all three? And the issue that arises often with a financial power of attorney is if you set it up so that two or more people have to work together. Many of the financial institutions, the brokerage firms, they don't want to work with two people together on a power of attorney. And I've had it in my past history where some financial institutions have refused to honor a power of attorney where they were required to work with two people together. So, just to make it easy, if it's practical, we often, if the couple wants to name both of their children, sometimes they're like, well, they're both capable, and we don't want to be in a position where we have to choose one over the other. Maybe that married couple, each of them will have a power of attorney saying, I appoint my spouse first, and then as the backup, I appoint my two children, and here's the magic words, acting jointly or separately, meaning if you become incapacitated and your spouse is not available to handle things for you, then either of your two children has the authority to deal with financial accounts and other important matters like that. And many parents say, our children are going to consult with each other anyway, so and maybe they say, and one of them lives out of town and one of them is busy, so I think it is good that we say either one of them can act. All right, so bottom line here, the financial power of attorney, it's one of the most important designations that you make. Choose carefully. If you're married, you'll likely choose your spouse first in case your spouse isn't the right person. Sometimes couples come in and one of those spouses is starting to slip. And so the spouse who has good capacity, the family may agree, well, let's not put anything, let's not put that spouse who is starting to slip, or whatever you want to call it, let's not put that spouse in charge of anything, moving forward. Let's just, let's name the child first, or, so occasionally it's appropriate where a spouse is not the first person named on a married person's financial power of attorney. Sometimes you see couples get married later in life and they're not leaving things to each other. They're leaving things to their respective children. They'll often name an adult child or children as first on their power of attorney. So all that, can be discussed, but choose carefully. The other thing that you need to really choose carefully on is you need to choose to hit the like button. And that'll make our YouTube algorithms happy so we can share more of the good news with more people. And then even more people will get this information if you hit the subscribe button and the notification bell that comes up. All right, so real important designation. Often, couples ought to discuss this stuff before they meet with the attorney. It's just a quickie discussion when you're meeting with the attorney because there's so many other things that need to be discussed. So if you can give this some thought ahead of time, you'll be better off. All right, we'll see you next time.